because of vote dilution through reapportionment. That's more context that is, let's say, one would have to read into this and isn't necessarily read into it with the words on the page as they currently are. But that totality of circumstances, again, we list one example circumstance or factor. The other ones that could be considered by, again, the enforcement agency really will be the AG's office to see if they believe it's worth bringing the claim. And then the court's ultimately saying, yes, that is the case or not. But, so we have, I'll say the statute is silent as to what some of the other possible factors could be here to show that a violation of subsection A has occurred. Being one example listed in subdivision B, and then really the discretion, the prosecutorial discretion in C, and then the actual, determination by the adjudicating by the courts.
So I felt like letter C kind of negated the need for that last sentence in letter B, because it seems like letter C has it covered. Nothing in this section shall be construed to establish a right to have members of a protected class selected in numbers equal to their proportions. So like quotas, for instance, population. So I'm not really sure what we're doing with the last sentence of letter B, but you gave a good explanation, and I know there are other questions, so I'm just going to leave that hanging there for a few minutes.
Okay, if I saw the hands in order, I have Rep. Waters Evans, then Rep. Stone.
What is, so this language, can you remind us what this language is based on, like where it originated from and like how closely it mirrors either Virginia or the federal?
It is pretty similar to Virginia's. I have to take a closer look to see line by line where it changes, but that was something it was based off of. And there was, if one is interested, they could look at the prior versions that the Senate was considering, which were much lengthier, there was additional processes, definitions, consultants, those different mechanics for how, let's see, different kind of violations would be considered, what were violations, things of that nature, which have been stripped out. And just to give you a preview, the bill as introduced, I think, was 25 pages, and then may have jumped to 50 pages, and then it was reduced down to like 6 or something like that as it came over here. So it's reduced, streamlined. I'm sure people will characterize it as.
And then those lines 12 to 14 in section B about the extent to which members of a protected class have been elected to office in the state or municipality is one circumstance that may be considered. That is, that doesn't, including that language doesn't single it out as more important or significant or something to be considered more than any other factor, correct?
No, not necessarily.
Yeah.
It does provide the only example of factors. So, but it wouldn't necessarily state that, other factors have to be greatly related to that necessarily.
And like giving one example or establishing one factor doesn't mean that any others might not be considered, right? I'm good.
Rep. Stone.
Going back to the totality of circumstances, standard seems to be too vague. I was wondering if you could talk about the Supreme Court decision in Thornburg versus Peoples 1986. I just attended a webinar about the Virginia Voting Rights Act, and I know that this language is closely modeling the Federal Voting Rights Act of 1965. But they spoke about in the webinar that I attended, that totality of circumstances language has like any challenges to that. Identical federal language has consistently failed. I didn't know if you'd researched that case in particular, because that's what developed that concrete multi-factor framework that courts use to apply exactly to the standard is what we heard. I was wondering if you could share a little bit about that? And then also if you could go over how section C is a limiting clause, not a contradiction, and kind of take us through what limiting clause
Sure.
means, like.
Well, first I'll start by saying, unfortunately, I won't be able to recite the holdings of the top of my head. I'd be happy to provide the committee with pithy summary of the case and maybe what totality of circumstances meant in that and from a subsequent case law. Happy to provide that, not a problem. And some of the examples as applied. I think that'd probably be helpful for the community to know. Getting to your second part of the question about is subdivision C limiting, or as you said, isn't. So nothing in this section shall be construed to establish a right to have members of a protected class elected in numbers equal to their proportionate born population. Is it limiting or not? It again gets to this historical idea of the racial quotas not being permitted constitutionally. And then that's a different context of voting, but sorry, let me just thinking about this out loud. Apologies.
Good.
Yeah, it would really reading the prior sentences on 12 and then kind of when subsection C beginning 15 together, it's really say, okay, with reapportionment or racial gerrymandering, which is really what we mean by like voter dilution here. We're talking about protected classes of people. It says, okay, when you're looking to see if there's been illegal racial gerrymandering through cracking, packing, that kind of thing, really primarily considering race and how to disenfranchise people of that race, really, is what we're kind of getting at here. One of the factors can be considered is, okay, was this seat historically held, or could it be historical examples of it being held by this candidate or a officer of that racial group? And then if it's lost or lost in significant numbers, there's multiple ones, they went down from 10 to 2 or something like that in a district with, say, 20, that's pretty significant. But so that can be one example of, okay, that plus numerous other factors to be considered in totality of circumstances, that can be considered that historical, where they were then not a seat holder. Now turning to C, we say, okay, well, that's fine that they could have held that seat or not, or at one point held it. But what we're not considering here is that X number of seats have to be held by this class of people or that class of people or this class of people here. So saying that it's whether it's limiting or not by this way to put it, but it's rather okay, the purpose is not to establish or meet any sort of quota when it comes to protected people, classes in the reapportionment process. However, what is more considered disenfranchisement, by again weakening the power of the vote or vote dilution is what we're talking about here. That because lines are drawn in such a way to so that this group has less voting power, or this opposing group has more voting power relative to each other, that could be considered inappropriate. And an instance of proof of that would be the disappearance of individuals of that class in those seats. Long-winded, not sure if that's helpful, hopefully.
Yeah, no, it is. And again, this is federal language that has been in place and survived decades of constitutional challenge. This is not something that we as the Vermont legislature have cooked up.
Totality of circumstances appears in.
And Part C as well.
Sorry?
And the Part C that we're talking about.
Yes.
That's all pulled from federal law that is held up for decades.
Yes, those aren't really considered facially appropriate or anything like that. Indeed, totality of circumstances tests in this regard have been upheld for decades.
Right, there you go.
Thanks. So part C is not the part that I'm objecting to. It's part B, the final sentence in part B. And I just went back to the Senate version, I think it's 2.5, the second version they had. And I see this language of a violation of subdivision plan is established, et cetera, based on the totality of circumstances. And then it goes on to list a whole bunch of criteria that are included in the totality of circumstances. So that version is much more expansive and descriptive than this one is. And I'm not seeing the extent to which members that sentence that I'm just not finding that unless it's somewhere in here that I have skipped over. So I'm not sure where that one sentence that I don't think is necessary is.
Is that a question?
Yeah, I guess. I mean, if anybody else can find it, that would be great.
Is the question, where did subsection C come from when the bill is introduced?
C
or-
is fine. I understand C because C is saying we don't want this to say there have to be quotas or thresholds or anything like that. It's the last sentence in B. The extent to which members of a protected class have been elected to office in the state or municipality is one circumstance that may be considered. But the Senate bill originally had a whole bunch of circumstances. Now we're just calling out one circumstance, and I'm not sure why just one if we're not going to use all of the circumstances. Is that as clear as mud?
Well, what I was gonna say is, I mean, that's why I just asked Tim, if including one would exclude others, and it seems like it doesn't. So I'm wondering if perhaps this one, and I couldn't speak for, I don't know what the Senate's, what their thought process was, but it seems to me like including this one particular sentence, it seems to me it could be because it's important or it's a good guiding principle. I can't presume to guess why they would want to leave it in, but my opinion is that it does no harm to leave it here, and it's a reminder and kind of a general guide of what our intent is with the legislation. And if it doesn't mean that other things aren't included, then it seems fine to me to leave it here. It doesn't seem like it's limiting us in any other way, or making this more important than the rest of the things. Although I would be open to adding everything else back in. That was taken out, all the, no.
It's a lot.
She just made it. Well, I'm just saying, if your
No,
concern
she's
is not having things in there, then we can just put them all in there. Otherwise, it seems to me like this might be kind of the overreaching principle of why we need to make sure that we're doing this. And I feel, I don't know, I guess it doesn't seem egregious or like it's gonna cause complications in any way if it's left in.
Okay.
Yeah, why are you frowning at me?
Yes, up next, Rep. Hisnall, then Stone, then Hago.
I'm just wondering if you couldn't tweak that sentence so that it doesn't just make it one circumstance, municipality is one circumstance may be considered. Is one example of a circumstance that may be considered or something so that there's other circumstances.
Our go-to language is includes, so we say includes, and that statutorily means how we interpret it through Title I is that includes but not limited to. So if the committee does want to explore something like that, they could rephrase it to see where are we?
Municipality includes.
Sorry, I lost my place here. Something to the effect of, okay, totality of circumstances. You can explicitly say an example of, or one of the circumstances may include, circumstances may include, and then say that example. And then the courts would say, okay, we know what that means. It's just one instance. It's not exclusive. It's an open-ended list of this. And it really wouldn't be, I'll just say that, yeah, those circumstances could be explored as wanted by the Attorney General's office, and then those appropriate, the appropriateness of what factors are considered would be weighed by the courts.
So then would that be in line, that lines, starting on line 12, the extent to which members of a protected class have been elected to to office in the state or municipality is, and what you said?
Yeah, I'd probably rephrase this, putting the first part of the second part of the first, so it'd be, circumstances that may be considered to include
Okay.
that to them.
Stone.
Okay, so I just want to point out again that the language that is in section B is from federal law that has been litigated hundreds of times, and I would caution us from deviating from that. Because I think the way that it's written now is illustrative and not exhaustive. And I worry that if we made it an exhaustive list and something that is new, that has not been tested, litigated that it could actually weaken the bill and put Vermont on the hook for things. So what I've heard from my research and reading and looking into these cases is there's a reason that they didn't list out specific things so that it was illustrative, non-exhaustive. And again, mirroring federal law that has stood up litigation for decades.
Is that last sentence in the?
It is. All of it's like one big package deal, like A, B, C equals C. So it's all from federal law. Like you can look it up on Google and you'll see it's literally like the language.
And again, like one of the to kind of anchor your point, Representative,
Yeah.
like one of the intents within this bill is to put the existing framework that has been federal law for decades in state statute.
That has stood up time and time again to litigation and has won. So I just worry that if we start messing around with things.
And that's one of the reasons that this bill itself was trimmed down so much. As the
Yes.
Senate had already gone through this exercise of expansive language
Yeah.
and then decided that it was better to have it tight, concise, and mirrored to federal.
Yeah.
Right, are you all set?
I'm done. I'm just saying that's a point of information.
Yeah, no, I was just asking before I moved on.
Yeah.
Representative,
Okay, so I'm not relying on a Google search. I'm relying on our attorney here, and I thought I heard Tim say that there were other circumstances that are in either the Virginia Voting Act or federal law. And I may have misheard.
I'm not just relying on a Google search. I'm also relying on the fact that it's in statute. And I'm sure that Tim can also point us to that.
That's what I'm asking. Thank you.
So I would have to pull up the Virginia statute to put side by side exactly how they flesh out the idea of totality of circumstances. Very confident that it does look pretty similar to something that existed in one of the earlier versions of the Senate bill. I have draft 1.1 of their strikeout amendment in Senate GovOps. And on page 6 of that, we have the in the evaluation of voter suppression vote dilution, an evaluation of totality of circumstances in determining if the violation has occurred. And then we have a series of factors kind of enumerated. And I have to double check to see if this is exhaustive of what they're thinking. But I can read some of them into the record if the if you would find that useful or not. And I would have to look into let's see, have to probably think more about, and so Thornburg, the other side of that case is Thornburg v. Jingles, or Jingles, depends on how you pronounce it. There's various factors that are used in that. And those are common law. They can be codified in various state laws. Doesn't necessarily mean they have to appear in state law for them to be considered. The courts, both Vermont and the US District Court here and all the federal levels would certainly employ the jingles factors. They're still very been upheld even very recently, just through some notes I have here. And sorry, I'd have to kind of produce, yeah, there it is. Allen v. Milligan in 2023, that was the most recent instance of when they're upheld. So anyways, I can produce some written materials or just come back later this week and actually kind of go into that more detail about what those factors usually look like. It's off the top of my head, they can be things like, well, maybe it'd be useful for me to read what the Senate considered first, or I'll just take the temperature of the room here if they find that useful to read into the record to see what's been removed in this part of the bill. I defer to members there.
I've been looking at draft 1.1 as well as 2.5, and that's what I'm trying to figure out of what the Senate considered is why they felt they had to remove what appear to be relevant pieces of this consideration of totality of circumstances. And not sure why they chose just to keep that one. And my question was, much as what Rep. Stone was saying, is it because that's the only sentence that exists in federal law or in the Virginia Voting Rights Act? That's the gist of my question. I just want, I guess, affirmation of that. Because if that's the case, what we're trying to do is mirror federal law. But I'm not sure why the Senate was considering all this other language. So I guess what we see the words on the page here in draft 1.9, is that federal law, and is there more to it or not?
I will say there's more to federal law than draft 1.9. The Voting Rights Act, as it's been amended over the decades, is much more involved than just the 7 pages that we have here. But they also address broader topics as well. So there's things in the Voting Rights Act that don't necessarily appear here, or they appear here in truncated. Yeah. Very much kind of abbreviated,
Okay.
I would say. Whether that exact sentence appears in Virginia law, I'm pretty confident it does. In federal, I'll have to double check. In regard to as why Senate took those out, you can see comparing draft 1.1 to 2.5, they removed it in 2.5. I would have to defer to the reporter, Bill from the Senate Gov Ops Committee. Can't remember who it was off the top of my head.
Okay.
But they would probably be able to give you an educated answer.
That's okay. I know we're going to hear from a number of other folks, so maybe somebody else will be able to answer my question. Thank you. We should move on.
Do you have a handout or Rep. Myers? Rep. Myers? Yep.
Oh, I just looked up the federal law on the United States. The House website, and I can send a link to the committee if you like, and it says it is almost identical, and it includes it says A, and then its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion in the population. And that's like literally what it is. There's nothing more there in that section. So it seems like it's the same.
Okay. So. Anything further on this? I mean, we're gonna have this bill in front of us all week, so we'll have time. Shall we? Yes, Roxanne?
It may be helpful, it won't be me, and you know, when I Googled it, did go to the same, I'm sure, government website that's public information, because we live in America. How amazing is that, we go our laws and just read them, but maybe it would be helpful to put that up as like a document so that we can have that just as reference as we're looking through in the committee and not having to wait for ledge council isn't here if we have a question, just to see what's already in federal law. Yeah.
That link that
Yeah, we can do a link,
Okay.
yeah.
Yeah, I mean, it's public,
as a
but
reference.
just that, so yeah. That's reference.
I can post it.
Okay.
All right. 2803. Impairment of voting rights of registrants.
And look here. I have to go to another committee.
Okay.
Okay. Oh, we're at a clock with you, sir? Oh, that's right. We had 45 minutes.
But I'm happy to return with more answers and information later on this week. And if individual committee members have questions that they want, send me, and I can provide it, make sure I have time to do satisfying answers. I'd be happy to.
Are you available at 9:30 tomorrow morning?
Doesn't look like it.
Okay, never mind.
Although I've been blocked off for 2 hours for probably something that'll take 20 minutes. So it's
For which one?
in House Ways meetings. Or it's 255, the pilot project for Wyndham County.
Okay, because I was gonna kick a vote on a charter that you were free around 9:30.
And okay,
Yeah.
thank you.
Yep, thank you. All right. All right, committee. So I guess sort of next steps on this, we have a good amount of testimony lined up on this tomorrow afternoon after the floor, looking at about 6, 7 witnesses. And so if folks want to read through this a little bit more granularly and identify questions for council, fire them off via email or however you'd like to correspond to start sort of getting an understanding within this, and then we'll pick up the testimony tomorrow, I guess, was like a little bit of a scant walkthrough. So tomorrow will be a little bit of a combo pack of a walkthrough and testimony. So maybe what we'll do is adjust our schedule for after the floor. Nick, could you?
Could I ask a question before you
Yep.
take us off here? 'Cause
I will, yep, I just want to ask.
Wasn't sure if you said today.
Nope, yep, no. So we'll finish the walkthrough maybe before witness testimony tomorrow. So let's see if we can line up Tim for that as opposed to 9:30. Rep Pismell, your question.
So I'm just trying to follow what's happened here, because the last time we had the bill, did we refer it back to the Senate?
No.
So how did H 541 get incorporated into that?
So requested the judiciary committees, that's why we had Rep. Good now.
Okay, so then it went to legal counsel and they did the work. So this is their language? Okay, so am I reading it wrong that the part of the capital campaign capital finance monies?
Page,
I'm on page 6 of 7, way at the bottom. Just as expenditure, capital A.
Yep.
Expenditures may include those expenses that are necessary to allow a candidate to campaign, such as expenses for care of a dependent family member that are incurred as a direct result of campaign activity, or for provision of monitoring systems, protective detail, and cybersecurity related to the candidate's security.
correct,
So once again, it doesn't mention anything about guns.
correct,
And it doesn't have a dollar amount maximum allowed to be spent.
correct.
So if we were concerned about that, then when we get to that part, that's when we have to tweak it and send it back.
Yeah, we did tweak it because now it's only allowable for monitoring systems, protective detail, and cybersecurity. So the acquisition of a firearm and other things is no longer allowable.
But what do you consider protective detail?
That sounds like security,
Like a bodyguard.
like a bodyguard.
But the previous bill said that you couldn't have a family member being you protect. This doesn't have that. Or was it one of the other states that said it couldn't be?
That might have been one of the other states on the NCSL.
On the NCSL.
Because this language, the highlighted language, the or for and further is the only thing that's changed because it was just spoke directly to security. And so honing it in was the agreeable decision coming out of Friday's testimony. Rep. Waters Evans, there you go.
I think I could help.
Yeah, I was just gonna say, I think that instead of going through all the things that you're not allowed to have, or kind of leaving it open to, like Tim was just saying with the other thing, if we just say this is what it's allowed to be used for, then it excludes everything else, as opposed to saying you can't
The
use it.
never ending list of hypotheticals.
Yes, if you say you can't use it for firearms, but then someone's like, well, is a BB gun a firearm? That's what I'm gonna buy. Or what did we say the other day? Ninja stars or
Dart gun.
whatever. Yeah,
Dart
dart
gun.
gun. Like there are a zillion other things you could use it for. Instead of opening it up to all those other possibilities, we're just saying you can use it for X, Y, and Z, and that's it.
A protective detail is pretty open.
I think it means security detail, but I bet Tim could come up with some language that says it's something more specific about what protective detail
There could be
is.
like a definition of that that's existing that he's working from, because I know that that was language that came from other states that had honed this. And Rep. Hango, did you still have comment?
I
Then
do,
Rep. Coffin.
this might help Rep. Pincinot. So if you look at the bill as passed by the Senate, when it came to us, on page 7 at the very bottom, it says, or for the provision of security for the candidate. What we're doing with this new language is to actually, as Rep. Waters Evans said, hone in on the things that are allowed for the provision of security for a candidate. So the Senate sent it to us very open-ended. And that's when Rep. McCoy, when she testified, said, well, could you use this to buy a firearm? And we were like, oh, we didn't consider that. So by honing it in to those 3 monitoring systems, protective detail, and cybersecurity, we're actually saying these are the only things that are allowed. Does that make more sense to you?
It
where that
does,
came
but I
from?
still think it's too broad.
And when we get to that section with Tim, that we can ask him for a definition of protected detail and offer a suggestion
Okay.
to change if it's still not palatable.
That's why we're dedicating a lot of table time to this week. Rep. Coffin.
Yeah, I just, for a note, for the committee's note, I'll have to ask Tim about this, but with the section 1975, interference with voters and election officials.
Are we?
On the side by
It'd be
side.
on page page 4, line 15 of this newest version here, 9. Okay.
Okay.
What I'm worried about is because, where we do a universal vote by mail. Okay, there's nothing in here that protects someone at home from any intimidation to vote. Whether you have people going door to door to get people to make sure they fill out their ballots or whatever, there's nothing in this for people at home. Or say there's an abusive relationship. These people, for somebody to be intimidated. Okay, there's no protection there at all for them. There's no, how do we, if this is about the purity of election, how do we, and as far as interference, when there's a mail-in vote, how do you know that that person actually filled it out and not the abusive member of the,
You don't.
you don't.
Well,
There's no protection there. So it's great and I'm all for it. No, voters shouldn't be intimidated at the elections. But how do we, if we're gonna mail everybody the ballot, how do we make sure that people are not being intimidated? That they aren't being coerced? This is, and that's troublesome to me.
Waters Evans, or did Hango? Waters Evans and Hango.
I wanted to address a couple things. First, Red Pins Not. I did do a Google search, but I saw it on several government websites, so I feel like this is, it's relevant. It's not just the Google telling me, it's like the US government, Department of State, et cetera, saying that, security detail is a thing. It does use the term protective detail a lot, but I am also seeing here, that it's used interchangeably with, personal security detail. So I wonder if making that language change would make you feel more comfortable, although security detail is like an actual thing. It's protective services detail, personal security detail, or security detail for short. And it's people who protect folks, particularly government officials. So it's an actual thing, which I didn't know, but now I know. But there are other words we can use if that is something that you would like to do. The other thing I wanted to say is I don't think that this bill in any way should be or is a vehicle for removing universal mail-in voting options. And I also, I think the point is to protect people from obstructing others from voting at a polling place, and it's keeping it really tight to those places, and whatever happens at other people's homes and what happens at the universal mail-in ballot, I don't think it's quite relevant to what we're talking about here in the denial or dilution section. That's specifically meant to mirror federal law. And if we start adding other things about if a domestic partner is forcing someone to vote the way they want them to, I don't think it's the same thing. And I really would object to even including any different language in this bill regarding that.
Welcome back, council. Thank you. Rep Hango.
I just wanted to thank Rep. Coffin because I hadn't really thought about that. I do feel that when we're talking about totality of circumstances, that just might be one of the things that an individual has to bring to law enforcement or whoever, and it will get investigated and it will get cured or whatever happens, remedied throughout the judicial process, because I don't think, as Rep. Waters Evans said, that this bill is meant to address situations in the privacy of one's home. But it's an interesting take, and I appreciate you bringing up that those circumstances definitely exist. And that's something to think about. And I don't think we're suggesting that we remove any part of this bill.
No, I wasn't suggesting that at all. So thank you for understanding that. And I wasn't suggesting to use it as a vehicle to get rid of universal mail-in ballots. What I was looking at it for was the actual making sure that people will speak out if there is a problem with that in a household. That's where I was going with it is, are there protections? Because it's not everyone has the courage to speak out.
And I think that's what way back, 1965, the Federal Voting Rights Act was trying to empower people who didn't have voices to speak out.
Right.
So it's a constant updating of that we have to make sure that everybody speaks out if they need to.
Mhm.
And people are reluctant to speak out in difficult situations. So this may be one of those situations that this bill cannot address, but it is a problem and it is an issue, and I appreciate you bringing that up. Because it's something else to think about.
Thank you. That's all.
I'll just say, I have witnessed it in the polling place. I had a husband and wife that she was very timid and he insisted on helping her vote, and I tried to tell him that he wasn't allowed to, that if she needed assistance, that one of the workers would help her, and he told me that it was none of my business, that he was gonna help, and you could hear him telling her, color that one right there, that one. So I asked him to leave. And he was so mad. Now he was.
Yeah, no, I mean, that's the
Said
right
that-
thing.
Yeah, but it does happen. So you know, it probably happened at home too.
So council was able to get himself released from his,
Yeah.
their obligation, so shall we pick those up moving on?
Sure.
So, section 3, draft 1.9 on page 3. So here we have a substitution from what was in the Senate bill, where those 4 new criminal and civil violations for interfering with one's right to vote and interfering with election administration. This has been, let's see, that language has been removed, and the singular offense that was in H 541 has been installed in instead. And that is why it's all highlighted. What should look somewhat familiar to this committee is because there was a flyby, or whatever we call it. When it was completed, came out of House Judiciary and came over here at one point before going to the House floor. And so just walking through this language again to refresh our memories. Page 4, we have a kind of cleanup and removal of confusing and to be redundant language in section 17, 1972. Again, just to orient ourselves in Vermont statutes annotated, we're in Title 17, so about election law. Chapter 35, which we have offenses against the purity of election. We have a lot of things about 1520 statutes about voter fraud and misconduct by election officials, largely. So we have removal of the last part of the sentence of subsection A of 1792 having to do with interference of voters, leaving it just being showing ballot prohibition there. And then we have the to be added section, which would be 17 VSA 1975, titled interference with voters and election officials. And this is where we have that no person shall intentionally and recklessly intimidate, threaten, or coerce or attempt to do so, and any other person for the purpose of A, obstructing the right of the other person to vote or vote as the other person may choose. B, causing the other person to vote for or not vote for any candidate for public office or public question in the election. Or, again, we have the no person shall intentionally or recklessly intimidate, threaten, or coerce, attempt to do so, a public servant, and two here, a public servant, an election official, or a public employee for the purpose of obstructing the administration of an election. With the penalties provision in subsection B, saying that a violation of this shall amount in imprisonment of not more than 2 years or fine not more than $1,000 or both. Yes.
Councilor Ryan.
So the ellipses.
Yes.
So I'm looking at as passed by the Senate, and they had a few subsections that are not listed that I'm assuming are in, that the ellipses take care of, but maybe not. Section 1934.
So all 4 of those in the Senate version have been removed.
Totally by this committee's direction.
Yes, through this amendment, it will remove all 4 of those.
Okay, so that's 1934 and 2022 and 23. Am I missing another one?
2024.
1934, 2022, 2023, and 2024. Yes, and this is where we have the side by side, if the committee wants to. discuss it.
Okay, thank you. And then I have a question about the words.
Yes.
I know we talked about it when we very first heard this bill, recklessly. What does recklessly intimidate, threaten, coerce, or attempt to intimidate, threaten, or coerce really mean? What is recklessly?
That's a fantastic question. So when we're talking about criminal provisions here, we have various elements of criminal law. We have the mens rea or the mental state of the perpetrator, and then we have the actus reus, which is the actual conduct which you're doing. Then we have victim, and then other aspects like, okay, then we have personalities that are, penalties, right of actions, et cetera, et cetera. But really the main two ones are mens rea and actus reus. So the mens rea here is these various mental states, which must be we go up the ladder for increasing awareness. And usually the severity of the crime is somewhat correlated with how much intention was involved with that. So we have 4 different levels. Starting at the top, we have purpose, or intentionally, we call it here. And so that is when one consciously desires a result. Then we go down, we have knowledge or knowingly doing something, and that is when an individual is aware that result is practically certain to follow. Then we get to recklessly, which is a conscious disregard. And see, when one consciously disregards a substantial and unjustifiable risk that the conduct will cause harm to another. And in the threats context, which is what we have here, it means that a speaker was aware that others could regard their statement as threatening violence and delivers it anyway. So you know what's going to happen, you just don't really care. And then below that, we have negligence, which is you're not really aware of the risk, but you should have been aware of the risk. So here we actually have 2 different mens reas. We have intentionally and recklessly. So we give prosecutors a choice. They can either show the top or the bottom. I will say constitutionally, when it comes to criminal threatening, and this is Counterman v. Colorado, I think it was 2023-24, where the U.S. Supreme Court explored what is the minimum mens rea that's necessary for criminal threatening. And they chose recklessness. So as long as you're showing anything, recklessness or above, being more intentful than that, then that satisfies constitutional requirements here. So by putting in recklessly, we provide that floor. So I'm not sure exactly under what circumstances the police officer or state's attorney prosecuting this would necessarily had on a higher mens rea, when all they would have to show is the recklessness standard. But they could.
That's great. Thank you very much. I recall some of that, but it really helped to have that reinforced. I appreciate it.
Thank you. Yeah, I have just a general question that is for Rep. Hago. I'm confused. I keep getting a little lost, and I'm confused as to why we are looking at the Senate version of the bill that's been rejected in comparison to the one that we're looking at right now, because none of that language is any policy that's on the table for us right now. And so talking about things that aren't in the bill are starting to confuse me a little bit. So I'm wondering I'm wondering why we are looking at that if we're not considering voting on it at all.
Fair question. It's what came to us, and I'm trying to understand how we got to version 1.9. And I'm trying to help my committee members understand how we got to version 1.9, because not everybody was part of the conversations that we had about getting there. So that this morning, I flagged a few things that I wasn't sure where they went, like those 4 sections. I had no idea where they went. So I just got my answer. And that's why we're doing this exercise. But thanks for the question.
Anything else? Go back to council.
Okay. So we move on, let's see, from, let's see, next part of the bill is, let's see, we're on page 5, line 8. Reader assistant heading states disclosures for candidates for state, legislative, and county office. So we have two real of substance provisions here. We have first a addition to the current disclosure for candidates laws compelling the state ethics commission to provide informational resources to candidates. And then we have a suspension of penalties for those same disclosures for 1 year. And as well as any enforcement efforts that go along with those. So looking at section 4 on line 10, we have an amendment to 17 VSA 2414. The retitled Candidates for State, Legislative, and County Office Disclosure Form. The county office edition, that's just kind of correcting something. We never included county officers in the title of it when it was last amended in 2024, I think. That was just an oversight.
Just kind of clarifying. Yeah. I think that came up in conversation as like a murky, unidentified.
And so you all may have recall, I think it's actually been one election cycle since this has been effective. So you've all gone through this exercise, most of you. And it comes to providing certain financial information and disclosures when filing for your candidacy for these offices. As well, it would have to be the same done by state officers as well as certain county officers, essentially those not the judiciary. And so, let's see, 2414 details all the information that needs to be proffered by the candidate, and then let's be adding a new subsection F to that stating State Ethics Commission shall provide informational resources to candidates and answer candidates' questions regarding the requirements of this section, how to accurately complete and submit the disclosure form, and the consequences pursuant to section 2415 of this title for failing to properly file the disclosure form. 2415 is the companion statute, which essentially states that if a candidate does not provide the financial disclosure, they are dinged for $10 a day. It can will be capped at $1,000 total. And then there's kind of a mechanism in there where the Secretary of State's office alerts the Ethics Commission, and the Ethics Commission pursues those fines. So, but those fines and the alert and pursuit mechanism will be suspended for 1 year by section 5 here. We've titled suspension disclosure requirement and penalties for candidates for state, legislative, and county office. Page 6 now, that says, notwithstanding sections 17, 2414, 2415, period June 1st, 2026 to May 30th, 2027. 1. Candidates for state office, county office, state senate, senator, state representative shall not be required to file the disclosure form or related documents described in 17. Sorry, I'm just reviewing this. Right. Sorry, well, 1 second, I'm just digesting something. I think I want to make sure I'm getting my version control correct here. Hard to file. So then the office of. I apologize, Chair Byron. I think this should be somewhat corrected. Because as written right here, it says that the will not have to file the disclosures. And that can be adjusted. I think I was going a little too fast.
Okay.
So
I trust your opinion on that, sir.
so I think what should appear in front of the committee is essentially the candidates will still have to file. However, any penalties will be suspended for a year, and then the enforcement that is usually required by the Secretary of State's office in hand with the State Ethics Commission would also be suspended for 1 year.
Okay, I understand where you're going with that, Rep. Hango.
I know what happened. Version 1.8 had it correct and it reappeared in 1.9. So
Leapfrog the draft.
Yeah.
Right, that's not,
Well, that's when I read this, I thought, oh, we don't have to file this year?
yeah,
Okay,
that's why we do
so it
walkthroughs.
should be, shall be required to file, instead of not being required.
I think what we'll do is after we finish this walkthrough, before we get into tomorrow, council will just redraft it with the correct language. And we'll have it in our inboxes tomorrow morning, so we have the correct copy to work from then. Does that sound amenable?
Sounds smart.
Yes.
I'm not sure if you can do this, Tim, but as a background for folks who were not here in 2024, where this concept of having to file a financial disclosure form.
I could talk all about it.
I would defer to one of the other committee members there, as far as the intent behind the legislation. I can't really get into that.
But it came from a particular act is what I'm getting at.
Yes, Act 171, I think it was 2024. That was the ethics bill for that year.
Yes.
That was a rather large bill that had municipal ethics, giving the Ethics Commission some enforcement-esque powers, and then revisited some of the disclosure requirements for not only candidates, but also for in-office office holders.
And so this disclosure form we're talking about now is something that was put forward in that, and this is more for the newer members who are not here, who don't remember the backstory. We didn't serve on the committee then. And so the charge and duty on the Ethics Commission to move forward with this, also with the ability to offer, to be an informational resource for compliance, for the candidates, et cetera. There was a disagreement about the language being clear that the charge and duty was on the Ethics Commission. So what we're doing now is clarifying that. And also recognizing that they are a little skittish about being able to like work directly and how am I trying to set this up?
I can
Yeah,
assist
please go
whenever
for it.
you're
Yeah.
ready.
No, go for it. I'm kind of stumbling over my words right now.
Well, I don't know how far back you want me to go. So 2 years ago, right? Last biennium, at 3, was it the first or second
3.
year of the biennium?
It was the second year, so 3.
Oh, yeah, okay. So
Yeah.
this big ethics bill that we passed had some changes to the financial disclosures for candidates in it and added penalties if you didn't complete those forms in time, because often candidates, of course, no one in this room would ever dream of not turning their forms in on time, but there are others possibly in this building who do not. And so those people, there's a fine of $10 a day when you're late. There is a system, I believe, that we kept that's in the bill where you get a warning first. It's not like the day after you miss the filing disclosure, there's $10, but right?
Yeah, there was like, there would be
Yeah.
a notification of that you
Yes.
remitted, yeah.
You get some
Yeah.
warnings. And then if you still don't file your form, then you have to start paying these $10 a day penalties up to $1,000, and then it's not. So in theory, I guess if it were worth it to you to spend $1,000 to not disclose your finances, then you could. It's mostly in the interest of transparency and disclose any.
But you're not allowed to use campaign cash.
Nope, you cannot use campaign you can't use campaign donations for your lateness on your.
For your
form.
late fees.
Yes, the intent behind it, and I know so much about this because I was the reporter of the bill when we did it, and it was like a big, huge, long thing. And so the intent behind it was just to make sure that people were incentivized to disclose that information, and the penalties were supposed to be as such, but so if you remember when we did the budget, the Ethics Commission, when we made our budget recommendations, had asked for another or 2 other positions. And I believe the final recommendation out of appropriations budget, the one that we voted on and sent to the Senate, was for 1 position. They're quite.
That was also municipal specific,
Yes.
not.
Yes, that was
Yeah,
municipal
very
specific. They're
specific,
just
yes.
overwhelmed and overloaded in all regards, apparently. So they, I believe the reason for the urgency is because there is a date coming up. And is it 27th?
27th Monday is when candidates
Monday.
will start remitting their signatures at the
Yes.
station and this disclosure.
Yeah, so the form has to be filled out and submitted on Monday. And that's why all of a sudden there's a big hurry to figure this out because there was some disagreement that came up really recently, like the last couple of weeks between the Secretary of State's office and the Ethics Commission about who exactly was in charge of the forum. The original language of the bill said that the Ethics Commission should create and maintain the forum. And I guess their opinion of what the word maintain, they're gonna come in and talk to about it, right? So.
Oh, yeah, we got them.
Yes, they're gonna come in and testify,
on this one.
so I won't
Yeah.
say what they're gonna say, but anyway, this is, the intent behind it was to make sure that people were just making the disclosures that they should. And because of, for now, I think the idea was to postpone it for a year, so to just make sure the Ethics Commission could get a handle on it, and so that candidates were in compliance with the law. Is that what we were looking for?
No, I think that was, you
Okay.
did such a better job framing my thought than I was capable of doing,
It's
so
like
thank you.
this.
Mhm. Okay, go.
So, for candidates, the disclosure form doesn't exist currently. So if you look on the campaign finance website, on the Secretary of State's office, they, charge is financial disclosure forms required along with their consent of candidate. Each candidate for non-federal statewide office, General Assembly and County Office must also file a financial disclosure form created and maintained by the State Ethics Commission. A link to the Ethics Commission's financial disclosure form will be posted here as soon as it's available. And then if you go to the FAQs, it says, each candidate for those offices must file a financial disclosure form created and maintained by the State Ethics Commission, along with their petition and consent of candidate. And that's all it says, because the form does not exist yet, and Monday is the start of the filing season. So Monday, the 27th through the 27th or 28th of May, whatever the last Friday is.
So I had Waters Evans, then
I believe there is a form that we all filled out even a couple years ago. The first time I ran for office, I filled out the form. It's just not the current iteration of the form that exists, right?
There's a form, but it's nowhere near as involved
yes,
as
it's not as
what they-
comprehensive.
Yes, it doesn't
what
reflect the
this
changes.
body charged them.
Yes, that's right. But there is a form.
There's a form.
There's the original form from
Right.
before we passed this law.
And that you can get right with your petitions.
Correct.
When you go to fill them out.
Right.
There, it's not to the extent that 171 was requiring.
Yes.
Rough boy, nope, waved off, okay. All right, folks. Any other questions for council? That's pretty much the run through on the words on the page.
We have one more section, actually.
Oh, crap, don't.
So now we move on to,
I never know this.
safety protection for candidates.
Yes.
So, this is section 6 was in the Senate bill. However, just the language at the bottom of page 6 and 7 has been updated. Committee members may recall that this is what in definitions where we have, what expenditure means, and then we list an example under 7A. And it said something along the lines of, or for expenditures may include those expenses that are necessary to allow campaign. Candidates to campaign, such as expenses for care of a dependent family member, are incurred as a direct result of campaign activity or for protection of the candidate. That has been replaced with or for provision of monitoring systems, protective detail, and cybersecurity related to a candidate's security.
Yeah, we were having a little informal conversation before you came in about that too, and it was instead of like enumerating all the things that you can't do, that this is saying, speaking clearly to the things you can do, thereby making the hypotheticals less robust. Does that make sense? All right, any questions there?
And so I corrected the error in this and this, sent, it to Nick, committee assistant, so that, the having to file their disclosures but not having penalized for doing so, the enforcement provision there, that will appear as it should on, section 6, pages 5 and 6.
Rapango.
Can you remind me what happened to section 5, if anything? Is it in those ellipses again, or?
Let's see, section 5, regional ones.
I'm looking at 1.9.
Section 5 is the suspension of the disclosure requirement.
Or do
It's 190.
section 5 of.
Okay, got it.
Yep,
Thank you. Sorry.
No, I spent a lot of time with these
Skimmed right
pages
over the
today.
highlighter.
All right. Anything else, council? Going once, going twice, going thrice? No?
Thank
All
you,
right,
Tim.
cool. So we're kicking things off tomorrow morning with the Burlington Charter at 9:30. We got some Civil Air Patrol going on at 10 a.m. and then we go into some more work on the early child ed licensure. So that's how the morning shapes up, and then we're going to get back to this bill in the afternoon with a big slug of witnesses. So, all right, that was dense. We needed to do that. Thank you very much. That was a lot of text to go over. I appreciate you guys. All right, anything else? Nick?